Welcome to the Migrant Center for Human Rights DreamWeek podcast series on advocating for justice and equality for immigrants under the Biden administration. My name is Sarah Ramey, and I'm an immigration attorney and the executive director at the Migrant Center for Human Rights, where we provide free and low-cost legal services to immigrants at our country's third largest ICE detention facility located in Pearsall, Texas. We present this program to you today in honor of the work of human rights defenders past and present, as well as our donors who have helped make our small corner of the world a better place for immigrants. Today's conversation will focus on border policy. A list of topics to be discussed can be found in the description box. If you missed our podcast on asylum policy, you can find the recording on our YouTube channel. We also encourage you to tune into the 3 other podcasts of this series later this week. More information will be provided at the end of today's podcast. By some counts, the Trump administration instituted more than 400 changes to immigration law and practice in the last 4 years. Our podcasts focus on the topics we see as having the largest impact on the immigrant community that we work with. The topic summaries presented here are intended to provide an overview of problems we believe need to be addressed by the Biden administration and Congress. It is our hope that these conversations will serve as a springboard for brainstorming ideas on how you can help ensure that Biden and our elected representatives in Congress align our immigration law and policies with our American values. The first action that the Trump administration took on entering office in 2017 was the Refugee Travel Ban, also known as the Muslim ban. This had several reiterations beginning on January 27th and was tied up in litigation for the better part of the year. We won't go into a lot of detail on this policy as the Biden administration has indicated that these bans will be eliminated as soon as he takes office. The Trump administration began to refuse entry to asylum seekers in the United States by basically having CBP officers tell individuals that the country was full, that there was no space, and that they couldn't be processed, and to ask them or told them to come back another day. Individuals would go back to the bridge multiple times and continue to be turned away in what became known as the Turnback Policy. This policy became more formalized when the administration instituted a metering program, giving individuals numbers and working with the Mexican government to set up a list and process cases. It's not clear why the administration felt that they should do this beyond simply wanting to deny access to asylum to migrants. There is no data indicating that the United States is unable to process refugee claims, and fortunately the Biden administration transition team has indicated that this policy will be eliminated and no longer carried out at the border. In January of 2019, the Trump administration went further in creating the Migration Protection Protocols, also known as the Remain in Mexico program. For more information on this program, please refer to our reflections that we put together after 1 year of the program running, and also look at the track data. It's very useful for understanding the intricacies of this program. To give you a brief overview of what we've seen in the last few months, starting in March with the outbreak of the COVID pandemic, the numbers of individuals placed within MPP began to dramatically drop off. So we moved from several thousand people being placed into the program every month to 124 in May, and then going back up slightly in the fall. In August, we were at 770. And you can look at the data by month following the link here, which will be accessible by opening the PowerPoint presentation. The links are not active in this MP4 video file, but we are providing a link below to the actual PowerPoint slides where you can find these hyperlinks. There have been more than 43,000 cases completed out of just over 70,000 cases placed into MPP. This means that there is over 25,000 individuals who are still stuck in this process. And these individuals have been waiting for a very long time for their court hearings. Starting at the beginning of the COVID pandemic, the administration postponed all hearings, postponed them again, postponed them again. It's not clear when court hearings will be reinitiated. Out of the cases that have been heard, only about 1% have been granted protection in the United States. A large reason for this, of course, being that asylum seekers stuck in Mexico do not have access to U.S. immigration attorneys who are unable to travel to Mexico and who find difficulty, even when individuals know how to reach out to them, find difficulty communicating in a confidential manner on a telephone. If we look at the numbers, out of 65,000 folks who were unrepresented, we have only about 5,000 who were represented. The issue with the MPP program, in addition to not having realistic access to legal counsel and the due process guarantees that ensures, it is the huge danger for people to remain in Mexico, whether they are in one of the dangerous border cities or otherwise located somewhere in the country. Individuals are required to travel through these border cities and present themselves at the bridge as early as 4 a.m. in some cases, and the gangs know this. They stake out people, they kidnap them. We've worked with a number of kidnapping victims who missed their court hearings because of that. So they're kidnapped on the way into the United States for their court hearings, as well as on their way out of the court hearings. People have been tortured, people have been abused in many ways, including rape of minors. The horrific things that have happened to folks is really one of the most compelling reasons to end the program. And because of all of these challenges, many individuals simply are not going to court. There are about 30,000 people who have been ordered deported for not showing up. If we compare this data to asylum seekers in the United States, approximately 90% of them are attending every court hearing. We've also seen the numbers of asylum seekers in the tent camps drop off. In Matamoros, the numbers have gone down from 2,500 to 1,000. This is because both of the danger, the lack of court hearings taking place, and also probably because COVID has shown up in the camps. In June, the first coronavirus case was recorded, and since then, at least 84 other asylum seekers have tested positive. Because of these difficulties, a lot of individuals in the MPP program have chosen to cross the border without documents, either coming across the Rio Grande River here in Texas or crossing through the desert further out on our western border. The Migrant Center has worked with a number of these individuals, and their stories can be found on our website if you would like more information on that. In October of 2019, the administration instituted what's called the Prompt Asylum Claim Review and the Humanitarian Asylum Review process. This is a process whereby individuals are required to stay in CBP custody for their credible fear and reasonable fear interviews. This means that they have very little access to counsel. These interviews take place in a matter of days as opposed to weeks or sometimes more than a month. When individuals are typically going through our asylum process, they will be transferred to an ICE detention facility. They will have contact with individuals who have been there for a while and can point them in the direction of reputable attorneys as well as nonprofit organizations. They will be given a full orientation program before the interview by the U.S. government and will have access to other legal services. In the CBP custody process, individuals, if they are so lucky to know who to call, often only have short calls allowed to them, and the number of those calls are also limited. Attorneys cannot easily get access to come in and meet with their clients, and the communication that does exist telephonically is not confidential. Out of 4,700 cases that have gone through this process, only 31 of these individuals have obtained legal representation. And we see that this has a very direct effect on the grant rates. So only about 25% of people are getting positive results on their interviews when they go through this process in CBP custody, whereas asylum seekers will typically receive positive results on their interviews, thereby giving them the right to present their case in court approximately 75% of the time. Unfortunately, on November 30th of last year, a federal district judge upheld this policy, and the plaintiffs will be appealing this. Briefly, with regards to border policy, individuals are being returned to all 3 countries that have signed safe third country agreements with the United States as of last month. Guatemala, El Salvador, and Honduras are now accepting individuals for processing and protection in those countries. We encourage people to listen to our podcast on asylum that explains why these programs are a violation of U.S. law and a danger to individuals. Lastly, Operation Capio is the CBP policy that uses the CDC's guidance under Title 42, Section 265 that allows the government to block the entry of someone when doing so is required for public health. The administration has denied entry to over 200,000 individuals, including 13,000 unaccompanied children. We highly recommend that folks check out our resource on this, as this policy is illogical, illegal, and harmful. We certainly have the capacity to test for individuals for COVID, and we can certainly quarantine where necessary. In fact, ironically, ICE has said that they can do this, and that's why they can continue to detain people in detention centers around the country. It's also a tad ironic, considering that the United States is one of the most dangerous countries to be in for COVID-19 at present. And so this idea that we cannot process asylum claims because a person might be sick really is contrary to our refugee protection obligations. And we are a developed country that can find a way of resolving any potential health risk that may be presented. So Biden has said that he will end the PACR HARP program as well as MPP, although it's not clear how people currently in MPP will be processed. He's indicated that all of this will take time, and unfortunately he's been silent with regards to the Title 42 COVID-19 restrictions. And so that's going to be the big place where we need to advocate moving forward. For MPP, the Migrant Center as well as many other organizations are calling on the administration to grant humanitarian parole. That would be permission to come typically for a year, but it would be renewable, and people should be able to get a work permit to support themselves during that time. Regardless of whether humanitarian parole or another form of case processing is instituted, and we certainly encourage the administration to not simply dump a huge number of people in immigration detention, not only because of COVID-19 and needs for social distancing, but because of the other challenges and harm that can occur in detention centers, in which we will be discussing tomorrow morning. But we need to look at how these cases are going to be processed. What are the priorities? Are we going to let people in based on the date that they were put into the program, so the people who are waiting the longest can have their process sped up the quickest? Are we going to look at who has the soonest hearing date, which will be somewhat similar but not exactly aligned with when people entered the MPP program? The logic here being that individuals with hearing dates coming up soon need as much time as possible to search for and secure counsel. Or will we prioritize vulnerable populations? This would require potentially an additional screening process, but it's worth considering making sure that families with young children, unaccompanied minors, LGBTQ+ individuals and women, individuals who have particular vulnerabilities to persecution in Mexico, that they be brought into the U.S. as quickly as possible, so that we're in no way in collaborating with the persecutors in the harm that people are suffering. It's very important to get stakeholder input, both of advocates as well as immigrants. It's not clear that the Biden administration has really consulted with individuals in MPP to talk to them and see what their ideas are and to get their buy-in into the process. And this is potentially an incredibly valuable idea or process that we would encourage the administration to do if they're not already, and to continue to do. Obviously also to speak with shelter workers and others that would be assisting immigrants who may be paroled into the U.S. in connecting with sponsors that they have here, logistics in terms of overnight housing, getting bus tickets, all of that. So what can you do? We encourage you to get together with a friend or family member or with a community organization and write a letter to your elected representatives, calling on them to pass legislation that's going to institute in a permanent manner the necessary protections at our border. We don't want to be in a situation where we're flip-flopping from administration to administration, and the executive can wield incredibly amounts of power to drastically limit our asylum system. We also want to make sure that our elected representatives are putting pressure on the administration to do what the executive can to make sure that we have humane policies at the border. We encourage you to create and sign petitions, tell stories to the press, call up your reporter, let them know that this is an issue that you as a reader care about. Write op-eds and connect reporters with immigrants who can speak on these issues directly to the public. We need to heal as a nation and come to some understanding around what the immigrant experience is. The negative rhetoric that the Trump administration has put forward, often incorrect, is very harmful, not in terms only of the impact it has on the way people feel, but also on the real policy implications. And we also suggest considering working with organizations like the American Immigration Lawyer Association and others who are working on these on a day-to-day basis as professional quote-unquote lobbyists, and who can make sure that the issues we're seeing on the ground for the people that we're working with are part of the debate in Washington. It goes without saying that the incoming administration really needs to change the tone surrounding the conversation on immigration in the United States. This is something that needs to happen not just on day one, but throughout the coming months. It's going to be important for the administration to not only re-engage with stakeholders at this point in time, but to continue to engage with stakeholders. That's immigration attorneys, the immigrant community directly, advocates, and every player in this area. The idea that we will have comprehensive immigration reform and suddenly everything will be solved is not realistic. There will continue to be things that our country needs to work on, both as we discover new issues with any legislation that's passed once it's implemented into practice, as well as the fact that most proposals that we've seen so far, including the indications of what Biden's proposal will be for day one, do not address every issue, and that there will need to be continued conversations on this. It will be important that the agencies are instructed by their heads to use professionalism, approach of customer service, and to provide reasonable response times to individuals as they seek to resolve immigration matters. It is important that the agencies have their mission language in welcoming, that their memos, their internal trainings, that all of this aligns with a humane tone that's respectful and that honors individuals' inherent human dignity and human rights. This is a time where we really need to reinstitute organizational cultures that will support common sense approaches to case scenarios. And we will be discussing prosecutorial discretion specifically in our podcast on detention policy tomorrow. So it does go without saying that we need to move from this language of rapists, of individuals who are coming from shithole countries, just trying to use the asylum system as a loophole to jump into our country. That basically we need to be decriminalizing our conversations around asylum seekers, understanding that the vast majority of asylum seekers are coming because they are fleeing persecution. It is not a choice. They would much rather, and we've spoken with hundreds of asylum seekers in the last few years, they would by and large much rather stay in their home countries with their family, their friends, their community, their jobs, than come to the United States, especially considering the dangerous journey that that entails. It is also important to decriminalize this language around immigrants' rights advocates and attorneys and humanitarian workers. So the person who's going to have a lot of play in this, of course, it's going to be everyone from the president on down to the attorney general. But with regards to border policy, we're looking specifically at the Secretary of DHS. So we're looking at Mayorkas and his ability to set the tone and to set the policies within ICE, within CBP, and within USCIS, all of which are important agencies in dealing with not only border policy, but asylum processing. We are calling on the administration from day one to stop attacks on aid workers and humanitarian assistance. CBP has destroyed water stations in the border, and the federal government has prosecuted volunteer aid workers. We believe that neither of these are helpful. There have been many deaths of migrants crossing through the desert, especially in the hot summer months, and we have to do whatever we can to end this tragedy. Obviously, we also need to be fixing the detention conditions in CBP holding cells. The holding cells are not meant to be long-term places. And they have become that in some cases where individuals should be there only for a few hours or a couple of days at most, but have remained for more than a month. And that needs to end immediately. And then even if people are going to be there for a short period of time, the issues with the freezing temperatures, thus the nickname ice boxes for these facilities, needs to be addressed. The issue where people are being forced to sleep on the floors or on thin mats, where they're given very little clothing or blankets, where there's no showers, and where the food quality is very poor. All of this needs to be addressed in a comprehensive manner. There also needs to be improved access to counsel and CBP facilities so that G28s can get signed and that attorneys can meet with their clients confidentially where that's needed. We also want to make sure that the administration does not target the sponsors of unaccompanied children for deportation. Under the Trump administration, a number of sponsors who had agreed to accept youth into their homes were then picked up by ICE and deported. And that's had a chilling effect on individuals wanting to come forward and support their relatives and family friends. So, you're welcome to read our op-ed on that issue, and we're hoping this issue goes away, but we want to make sure that we're keeping our eye on the pulse on this one. CBP is one of the largest, or I should say is the largest in terms of funding federal law enforcement agency in the country. It has a budget of $17.4 billion, and this is a budget that should allow them to have humane holding facilities and proper training of officers. We also believe that it's not necessary for the administration to transfer funding from other departments, as the Trump administration did, including from the Department of Defense, specifically to build the border wall. And luckily, Biden has come out and said that he will not be continuing construction of the border wall. But CBP agents, unfortunately, often do not face the consequences for their actions. And we've seen a lot of cases of abuse. We need stronger standards and training on the use of force within CBP. Officers should be asked and required to keep their badges with them to show who they are, wear body cameras, and the complaint mechanism needs to be a true complaint mechanism. There needs to be clear access through forms at the facilities for pro se individuals, an online process for attorneys and advocates to fill out, and then a uniform process for reviewing and investigating these abuses with real consequences. This needs to be an independent process. CBP has shown they're not effective at holding people to account for abuses. There also needs to be a very consistent hiring process to ensure that the individuals hired are going to live up to the most professional standards of representing our country. This is the first interaction that individuals often have coming to the United States. It's an important job. There are many good CBP officers, but unfortunately there are many who have also engaged in violations of the law. On border wall and border enforcement generally, Biden's proposal that will be sent to Congress tomorrow is planning on increasing technological surveillance along the border as alternative to building a wall. Interestingly, under the Trump administration, only about 5 miles of new wall were actually constructed. Most of the construction was for replacing old sections of the wall. And it's not clear if Biden is going to continue to maintain the wall that's already in place. It's also not entirely clear what he's going to do with the contracts that have already been signed. But he will be rescinding Executive Order 13767, which authorized the construction of the border wall. Again, one of Trump's very first actions when he took office in 2017. Now, the other issue that we would like to touch on briefly is the tracking of individuals through DNA testing and facial recognition software. There are several notices of proposed rulemaking that have come out on these issues that have not been finalized yet. So as we discussed in our asylum policy podcast previously, the administration has several options on how to deal with these. We encourage you to read that. The concerns here are that this technology can be an invasion of privacy that isn't needed, that facial recognition technology can be inaccurate and can lead to racial profiling, and that this data, it will not be safe from hackers. Currently, everyone 14 and older has their fingerprints or their biometrics taken when they go through immigration system, and that will continue. There's no reason that would not continue. And so, we're not talking about not checking criminal history. We're talking about not having extra things that are unnecessary and potentially violations of people's privacy and due process rights. Lastly, we are going to address criminal prosecutions. As most listeners are aware, the Trump administration instituted what has been called the zero tolerance policy. We take issue with this terminology because zero tolerance implies that the people who are being federally prosecuted for unlawful entry and re-entry under 1325 are somehow violating the law. It is very clear under international as well as domestic law that individuals have the right to seek asylum regardless of how they enter the United States. So they are legally here if they are seeking asylum, and regardless of whether they crossed EWI. So EWI stands for entry without inspection. It means that they've crossed not at a port of entry, not at a bridge or airport, but that they, instead of presenting themselves, they've come across the river or the desert. There's many reasons for this, including those that we mentioned before with with regards to the actual closure of the ports of entry, forcing people to take the more dangerous route, and also the fact that court cases, are not happening for the people in MPP. A lot of it relates also to the way that people are told to come to the U.S. So if they have a smuggler or if they're talking to other immigrants at a shelter, that's how they know to come, right? And it's not usually out of an intention to violate U.S. law. Many people, once they cross the border and they see CBP officers, will approach them and and ask to be given protection. The interim final rule the administration put forward on November 9th, 2018, fortunately has not come into effect, but the goal there was for the administration to take away the right to asylum for people who entered without inspection. We are 100% opposed to that policy, and we have an op-ed that you're welcome to read, as several others that we've included links for here. We also invite you to read Claudia's story about her separation from her children during the height of the family separation policy. DOJ, Department of Justice Inspector General, issued a report earlier this month, basically stating what we knew, right, that the administration was unprepared for the impact of family separation, both in terms of the trauma that it caused for children and continues to cause, as well as to their parents, and that the administration was in many ways ignorant of the legal requirements and how individuals need to be treated in our system. Biden has said that his administration will work to reunite this over 600 children who are still separated from their parents. It's unclear what additional tools he will use to make sure that this happens. There's a team of advocates who have already been working incredibly hard to reconnect these families, and under the litigation, there's a government team that's supporting that effort as well. It is really important that individuals keep in mind that family separation is not a new phenomenon, and that it continues today, even though the particular policy that was taking place in 2018 is no longer in force. So if a child is 18 or over, they're viewed as an adult. They will be taken from their family and placed in an adult detention facility. If the child has another parent or family member in the United States where they can reunite and will not be in ORR, Office of Refugee Resettlement Shelter, they have not been considered to be a family separation victim. And we worked with several families where the mother was in detention, where ICE refused to release the mom, and the kids were did not fall under this litigation, were not protected by what was all the advocacy that was going on because they had been released from ORR and were living with other relatives. But needless to say, nobody can replace the role of a mom. Nobody can replace the role of a dad. And the administration really needs to be aware of that and act on that. We also see other family members separated, so that's spouses, siblings, and others who are separated largely due to gender, because we don't have a facility that can hold both men and women in the same space. There are facilities, of course, including Pearsall, that have separate pods for men and women, but they don't interact. And this is just one more reason why detention is not the best option for case processing. So we hope that you will tune into our podcast tomorrow morning on detention policy. On Thursday, we will be discussing interior enforcement. Friday, affirmative benefits, including citizenship and the new proposal that Biden is sending to Congress. We encourage you to go to our website to find out more about our work and get more analysis on these topics. There are also job and volunteer postings available, and if you reach out to us through our website or at the email provided here, you can sign up for our newsletter, and we will be happy to keep you informed as things develop. Thank you again for your attention, and have a wonderful day.